This morning, my name is Mark Spence. I'm the Managing Director of Construction Employers Federation. And this morning, we're going to have a presentation from our legal patrons, Selig, and in particular, Richard Craig, who's partner with Selig and heads up their insolvency division. Richard's going to take us through this morning a presentation on insolvency in construction and how it affects you, how it might affect you via your supply chain, try and debunk some of the jargon, Richard, I think, as well, and obviously be available to take some questions. Just for your information, this session is being recorded. That's so we can share it with other members who were unable to join us this morning. We're using Zoom webinar, so down at the bottom of your screen, you will see a Q&A button. If you'd like to ask questions during the session, please submit them through Q&A. That can be anonymous. And then at the end of the session, Richard and I can pick those questions up on your behalf. So with no more ado, Richard, I will hand over to you. Thank you very much for presenting this morning, and we look forward to what you have to say.
Mark, thanks very much. Good morning, everyone. And yes, as Mark has just said, we're delighted to be patrons here with CEF for the next while, and we will be offering a number of webinars over the coming months, just covering I suppose a multitude of areas of law that Selig as a firm has expertise in. Just if you'll indulge me, just to explain a little bit about our firm at the outset here. If you don't know us already, we are a local and independent law firm here based in Belfast. We are experts in all matters of corporate and commercial law and are committed to offering you a comprehensive legal service, no matter the complexity of the case. And our 360 approach means our clients and you have access to our full specialist team who can provide a tailored advice specific to your needs. Of course, you would say, I would say this, but we are a really excellent firm, and hopefully we have opportunities to work with many of you in the future. In terms of what I hope to cover today, as Mark has already mentioned, I want to spend a little bit of time jargon busting. So insolvency certainly is quite a complex area of law, and there are a lot of terms, a lot of terminology, a lot of types of proceedings that aren't always very clear on first blush what exactly that means. So I'm going to spend a bit of time going through some of the main types of insolvency proceedings and giving a bit of an explanation. I'm then going to look at a review of the recent key developments in insolvency law. So this past year has been quite a dynamic year in terms of new legislation coming through and a couple of key developments, most notably the Crown preferential status being restored, which I'll touch on during my presentation this morning. Then I want to close off with just some brief debtor and creditor considerations in relation to insolvency that will hopefully help you consider, both from the position of a debtor and a creditor, what things you need to be thinking about. And then we will have plenty of time probably for some questions at the end or any comments, and it'd be great to have a bit of engagement on that at the end. And as Mark has already mentioned, if you do have any questions during the presentation, please do put them in the chat function, and we can look at as many of those as we can, time allowing, at the end of the presentation. So in terms of insolvency, what do we really mean? Well, insolvency itself describes the inability of a debtor to pay its debts as and when they fall due. In the UK, we have insolvent individuals are made bankrupt, while companies would be put into liquidation or administration. There are also individual or company voluntary arrangements as a common alternative to bankruptcy or liquidation or administration. So those are terms that we're going to spend some time just going into a bit more detail to explain. As I think everyone on the call today is a corporate entity, and maybe most of the entities that you're dealing with are corporates, we're going to focus on corporate aspects of insolvency today, but similar principles apply to individuals when you're dealing with, for example, sole traders in business. In terms of the order of priority, this is very important in terms of considering where you stand whenever you're either on the debtor or creditor side of an insolvency. The first preference in the order of priority belongs to the fixed charge holders. So that most commonly is a lender who has security over usually property or perhaps plant and machinery. They stand first. Then in an insolvency procedure, the insolvency practitioner, known as the IP, his or her fees and expenses then come next. Next on the list are the preferred creditors. Now that usually the most notable party in that would be the employees. And now, as I will touch on later, HMRC find themselves in that category as well. Next would be floating charge holders. So again, often lenders who maybe can't get fixed security, there's no fixed assets that they can get security over, but they can get security over the floating, the movable assets in the business. Following that then are the unsecured creditors, which is your standard sort of usual trading relationships in supply and customer type relationships. And then finally, if there is anything left at the end of that process, the shareholders of the company will get something back. In terms of liquidation then, liquidation is used to wind up a company and realize and distribute its assets to creditors and shareholders. Liquidation of a company can be voluntary or compulsory. So a voluntary liquidation is initiated by a shareholder's resolution to wind up the company, and that must pass a 75% of voting shareholders test in order to be approved. Two types of voluntary liquidation. We have a members voluntary liquidation, often known as a solvent liquidation, and then a creditor's voluntary liquidation, which is known as an insolvent liquidation. So the members voluntary liquidation, the MVL, must be accompanied by a statutory declaration. And this declaration is signed off by the directors of the company to essentially say that all debts will be paid within a period of 12 months, which is why it's described as a solvent liquidation. So in that case, everyone should be paid. For whatever reason, the company has just decided to wind itself up. In an insolvent liquidation, it's different because there will be some kind of shortfall, and that's why the creditors are more involved in that process. A liquidator would also be nominated by the shareholders, and in the case of a CVL, the creditors play a bit more of an active role in that they're invited to a meeting and they can vote on the proposed liquidator and have some more say or power as to who is selected to act as liquidator of the company. In a compulsory liquidation, that's initiated by the presentation of what's known as a winding up petition to the court. And following the winding up order, the official receiver, more commonly known as the OR, automatically becomes liquidator of the company. If the company has assets that can be realized for the benefit of its creditors, then it would be normal that an IP, a licensed IP, will be appointed by the OR to act as a liquidator. In the case of a compulsory liquidation, it's important to remember that any action or legal proceedings against the company in liquidation cannot be initiated or continued without the leave of the court. So if you are involved in proceedings with a company that then is wound up by a compulsory liquidation process, then those proceedings would automatically be stayed and cannot be moved forward without first getting leave from the court. So that's liquidation. Administration then is a procedure commonly used as a way to facilitate a rescue of the company or the better realization of its assets. The main advantage of an administration is that it allows an insolvent company to continue to trade with the protection from its creditors through what's known as a statutory moratorium. So this moratorium then prevents creditors from taking any legal action against the company or indeed enforcing their security against the company or its property. So essentially, the administrator, once appointed, gets a bit of breathing space to put forward its plan or his or her plan or proposal. The main objective of administration, as I've mentioned, is to rescue the company as a going concern. So that would be the first and primary objective. If this is not possible, then the second objective is to achieve a better result for the company's creditors than a winding up or a liquidation of the company without first being in administration. And if that objective is not possible, then the third objective is to realize property to distribute the proceeds to the secured or preferential creditors. This only applies, of course, if the first two objectives are not possible, and it will not unnecessarily harm the interests of the creditors as a whole. So perhaps some of you have experience with administration in the past, and certainly if you're in an unsecured creditor position, you may feel that that insolvency procedure is not particularly great. It seems to prefer the fixed the fixed charge holders and floating charge holders, and their interests are much better protected by the process. An administrator can be appointed either by an out-of-court procedure or by a court order. So an out-of-court appointment can only be made by the company through its directors or shareholders, or indeed by a qualifying floating charge holder. An application for a court order can be made either by the company's directors, or one or more creditors of the company. With an administration, the administrator has extensive powers to manage the affairs of the company. Essentially goes into the company as almost like a quasi-director with that kind of power and control. It also, he or she will also have quite extensive enforcement powers, which include bringing applications to court to challenge pre-insolvency transactions. So obviously from a creditor point of view, often the concern is that, you know, maybe some key assets will be dissipated in the lead up to an insolvency procedure. And it's important to remember that an administrator does have the power to challenge those transactions. Prepack administration then is a more recent scheme, and we've seen a lot of this over the last 10 to 15 years. A prepack is an insolvency procedure where a company arranges a deal to sell its assets to a buyer before appointing administrators to facilitate the sale. So it's essentially a done deal, and it's set up before the administrator is appointed. It's a very powerful legal way of selling a business onto a trade buyer or a third party. Typically, prepacks would be a good outcome for the secured creditors, but pretty disastrous for the unsecured creditors who are really left hanging at the end of the process. You may be aware of this term, Phoenix, which is has been one of the main critiques of the prepack procedure. Phoenix would be, for example, Richard Craig Limited goes into administration, and the next day Richard Craig Limited 2 opens in the same premises doing the same work, but they have lost or have got rid of a lot of the unsecured creditors. And for obvious reasons, that can be quite frustrating to see that happen. And there has been a lot of lobbying over the past number of years around this procedure to make it more fair. In fact, it's fair to say that it should be done in the fairest way, and the focus of the proposed administrator is always to get the best deal for all creditors, not just the secured creditors. And so we see this matter come up regularly, and a significant development earlier this year was the administration's restrictions of disposals, etc., to connected parties regulations 2021, very catchy title for a piece of legislation. And it's come in play really to make sure that the process is done fairly. And this has introduced the idea of a qualifier who will go in and review the transaction and make sure that that is the best outcome for the creditors. Now, it's important to remember that has come into force in England and Wales, but not yet in Northern Ireland. Our local executive will have to see that through probably in the not too distant future. Moving on then to company voluntary arrangements, or CVAs. They are contractual agreements between a company and its unsecured creditors. The main aim of the CVA is to enable the company in financial difficulty to propose a compromise or an arrangement with its creditors. In most cases, the CVA is commenced by the company's directors. However, if the company is already in administration or indeed liquidation, it can be proposed by the administrator or liquidator. With the CVA, it must be approved by at least 75% of the voting creditors who respond to the invitation to vote. It's important to remember that it's not 75% of the creditors, it's 75% of the voting creditors. At least 50% of those voting in favour must be unconnected with the party. So again, that's to try and bring a little bit of partiality to the process to make sure that the creditors are fairly treated. An approved CVA is supervised by a licensed insolvency practitioner, and although the directors of the company remain in control, they must fully cooperate with that IP to ensure implementation of the terms of the CVA. So most commonly, CVAs will last for a period of 3 to 5 years. There's no impact on the employees, and the procedure does not interfere with the company's ongoing business activities. So essentially, the company is free to trade on, provided it complies with the terms of the arrangement it has secured with its unsecured creditors. The approved CVA is a binding agreement between the company and all of its unsecured creditors. And this actually includes unsecured creditors who did not vote or participate in the process, even though those unsecured creditors did not even receive notice of the proposed CVA. So often I've had that query where a creditor has come to me and said, look, we didn't see the proposal and didn't get an opportunity to vote. You're still bound in by that proposal if it is approved, and there are only very limited grounds available to challenge a CVA, and the pure fact that you were not put on notice is not one of those grounds. So it seems sometimes a little bit unfair, but it's probably, as I'll come to later, why it's really important to engage both on the debtor and creditor side with one another in a process and keep a close eye on things to make sure that you don't potentially miss important notifications, like, for example, a CVA being proposed. Okay, so moving on to our second part then, recent developments. So as I said, there have been a number of developments in the past year, very exciting 12 months for insolvency. The Corporate Insolvency and Governance Act, known as SEGA, came into force on the 26th of June 2020, and it couldn't have been more timely in many ways, because this was something that obviously wasn't, it hadn't been planned in accordance with the pandemic, but with the pandemic coming in, there certainly was a bit more pressure and urgency to make sure that this came through perhaps slightly quicker than originally anticipated. Alex Sharma, the business secretary, confirmed at the time of putting through the legislation that the overriding objective of this legislation is to help UK companies which need to undergo a financial rescue or restructuring process to keep trading. These measures will give those firms extra time and space to weather the storm and be ready when the crisis ends. Probably back then, we expected it to end a lot sooner, it's fair to say, whilst ensuring that creditors get the best return possible in the circumstances. So this piece of legislation, you might say, is debtor friendly in the sense that it is giving the debtor the best possible chance to ensure a restructuring, a rescue, as opposed to a liquidation or the death of the company. There are two main types of measures introduced by the Act. There are permanent insolvency measures and temporary ones. The permanent ones, which I'll touch on just in a little bit detail, include moratoriums, restructuring plans, and I think interesting, especially for you folks on the call today, termination clauses in supply contracts. And then in terms of temporary measures that have been brought in, there has been a suspension in relation to winding up petitions. There has been a suspension of liability for wrongful trading and company meetings and filings. So those temporary measures, although they're all still in play at the minute, will have an end date, whereas the permanent measures, which I'll touch on now, will continue to be used in the insolvency process. So what is a moratorium? Well, this is kind of similar to in an administration there where there's a statutory moratorium. It's a similar type process, okay, and that the intention there is to provide breathing space for companies in financial difficulty. There are two ways in. There's an out-of-court and an in-of-court entry. If you're sitting with a winding up petition against the company, then they'll have to go to the court to seek leave and to seek a moratorium. But if no winding up petition has been presented, then an out-of-court application can be made. There's an initial 20 business day period, which can be extended by 20 more days without consent, or up to a year with creditor consent or the court order, or longer than a year if sanctioned by the court. So this is very interesting, and this has never been in play before, where you've got a process where you can essentially make an application to extend that moratorium. Now, because of the restrictions that are currently in place, we haven't seen the moratorium process being used, but as those temporary restrictions come to an end, we expect to see the moratorium process come into play a bit more frequently. Entry into and extensions of the moratorium are overseen by a monitor. It'd be a qualified insolvency practitioner, but the debtor remains in possession. So that IP, the proposed monitor, must provide a statement that in his or her view, the moratorium would result in the rescue of the company as a going concern. And we anticipate this will be very challenging. Perhaps now, as we hopefully are seeing the light on the other side, and we're seeing a process whereby normality is coming back into play, perhaps there'll be more comfort. But certainly whenever this was first launched and we were thinking about a second lockdown and a second variant and all that kind of stuff, some of that obviously hasn't totally gone away yet. But certainly when this first came out, it seemed impossible to really predict what was going to happen over the next period. And so that could make it quite challenging for IPs to make that statement. Moratorium then relates to payment of debts due at the date of commencement of the moratorium. So the company who enters the moratorium does not have to pay those debts and will not, and no action can be taken against them in respect of those debts. Interesting though, under the moratorium, payments to creditors in respect of debts incurred during that moratorium period need to be paid. So I suppose that is where the logic comes from, why you potentially would be allowed to have an extended period where the company is in this moratorium, because the company or the suppliers are not any worse off than they were whenever the process started, because any debts that need to be paid during the moratorium period must be paid. And if they aren't, then the moratorium will come to an end. The second process to the permanent measure that's come in is what's known as a restructuring plan. And apologies, this is quite wordy, but this is to be eligible for the company must show that it is encountering or likely to encounter financial difficulties, and a proposed compromise with creditors intends to either eliminate, reduce, prevent, or mitigate the effect of the difficulties. So again, a plan can be brought forward, not necessarily when a winding up petition is imminent, but where the company has had a look at its affairs and sees down the road we're going to be in difficulty. So this could be a measure used for a debtor if they are taking quite a proactive mindset to the process. This process involves an application to court, followed then by a meeting of creditors, where again the voting majority of 75% is required, followed by the court sanctioning the plan. So the fact that I've mentioned court twice in that sentence maybe gives an indication why this potential route maybe won't be as popular, because obviously with court applications, there's court fees, you have to pay lawyers like myself, and so this could end up being quite an expensive process, particularly with the court sanctioning process. If you think about it, a court is not going to approve a plan unless they're satisfied that the evidence is there to suggest that this plan is the best option for the company and indeed its creditors. And so it may be that there would be quite an amount of cost potentially to be incurred. And in fact, anything we've seen so far, nothing by the way has happened over in NI at this stage, but over across in England and Wales, there have been a number of cases that have been quite expensive drawn out processes when they've been considering this restructuring plan. There's a new power under the restructuring plan that includes, and this is probably the most interesting part of it, it includes what's known as a cross-class cram down, and that would bind all creditors, including a class of dissenting creditors. So under your standard sort of CVA, it's all the unsecured creditors are all in there in a group, and you have to persuade 75% of that voting majority. Under the restructuring plan, you could potentially pick some of those creditors out and put them in a different class, and they could still potentially be bound in to the plan. If they are the dissenting class, they may still be bound into the plan, even though they maybe hold enough of a percentage of the debt to vote against the 75%. So the court has the power to do that. And we have seen that sort of come through in a couple of cases so far, where landlords actually have been one of the class of creditors, and they've been bound into an arrangement that they're not happy with. So that's the restructuring plan. Thirdly, then, we have termination clauses in supply contracts. So what does this mean? Any contractual provision which envisages the contract terminating, or indeed any other thing, would take place, or the supplier being able to terminate the contract or supply, or do any other thing, ceases to have effect. So it can be further reaching really in that regard. So a contract can't be terminated on grounds of insolvency, is essentially what that's saying when it comes to the supply contracts and the terms and conditions that you may have with a customer. A contract can be terminated if the office holder or the company consents, or indeed the court is satisfied that the continuation of the contract would cause the supplier hardship. So we may, because again, there hasn't really been much activity on this front, but we may over the next several months to a year see perhaps even a bit of litigation around this, in terms of suppliers saying that this is unnecessarily harsh, that we would have to continue to supply this customer who is now facing potential insolvency. The supplier cannot require outstanding charges to be paid as a continuation of the supply in the insolvency procedure. So this again is a big shift, because if you have been, say, on the creditor side, where you've maybe been supplying a company that then goes into a procedure, often you may have made that proposal, like, we're not going to supply anything else until you bring our debts up to date. And in some cases, maybe if the administrator or whoever's dealing with it is an office, they've decided to take that commercial view. Yes, it's in the benefit of everyone that we do that. Now, no longer can that be insisted upon due to this, due to the provisions under SEGA. There is a temporary exemption that's in place now until at least the 30th of June of this year for suppliers facing hardship, and also some smaller suppliers, if two of the following conditions are met. So if the supplier's turnover is not more than 10.2 million, if the supplier's balance sheet totals not more than 5.1 million, or the number of suppliers' employees is not more than 50. So if you can tick two of those boxes, you can apply for the temporary exemption, which will allow you to terminate that contract. I think as a result, the main takeaway from this would be that suppliers need to be even more diligent than ever to ensure that they're comfortable with the buyer's creditworthiness. So again, early engagement whenever there are concerns or risks there, to make sure that any potential loss that may be faced by your company is suitably mitigated would be good advice there. In terms of the temporary measures, the only thing I want to touch on today are the winding up petitions. So there's a temporary ban in place to prevent statutory demands and winding up petitions being presented before the 30th of June this year. Now, over in England and Wales, it looks like that will change in June and things will move on from there. Over here in NI, the bankruptcy court, in fact, has not made any winding up orders unless and only in circumstances where the debtor has consented since 19th of March last year. So there's a number of winding up petitions that are sitting out there I myself have a few of them that haven't yet been processed because the debtor is not consenting to a winding up order. And that's still the case today. The bankruptcy court also in NI has not accepted any winding up petitions since the first lockdown back in March last year. And actually, there's no suggestion that this position will change anytime soon. So there have been some suspicions that in the autumn, winding up petitions will come back in play, but we're not actually getting that indication at the minute. So from a creditor point of view, this could be awful news. If you're sitting there maybe with a big debtor book and looking to issue petitions after the summer, it's unlikely that that will happen. And as I'll come to shortly, it's probably one of the reasons why I'm giving some recommendations today about the creditor's approach to debtors for the next period. The final sort of key development that I wanted to touch on this morning is the Crown preference. So this is separate to that legislation that's come in. As of 1st December 2020, the Crown preference, so the HMRC debt now ranks ahead of floating charge holders and unsecured creditors under the Finance Act 2020. So prior to that, HMRC was in there with the unsecured creditors. The elevated status applies to PAYE, employees' national insurance contributions, and construction industry scheme deductions, and VAT. Interestingly, HMRC claim is not capped by any amount or time, and the Act will apply retrospectively, so not just for debts incurred since 1st of December 2020, but for all debts would be into apply with that preferential status. This is really interesting and a big consideration now for everyone involved in whether it's on the lending or the borrowing side, because HMRC typically are one of the largest creditors in most insolvencies. So I suppose from the debtor point of view, that wasn't a major concern, or even from the creditor point of view, not always the biggest concern whenever they were an unsecured creditor. So you could rank ahead of them if you were able to get some security on your lending. But now, because HMRC rank ahead of even floating charge holders, that elevated status potentially will cause quite significant challenges for everyone involved moving forward. HMRC cannot be bound by a CVA anymore without its consent. So typically, again, on the debtor side of things, when putting a proposal forward, we find that HMRC can be one of the stickier creditors to deal with, and maybe not as agreeable as some others to the proposal, maybe not as commercially minded as some others to the proposal. And so they effectively now have this veto power because of their preferential status that may cause challenges for CVA proposals. And as a result, I actually feel like these new rules may stimulate an increased number of restructuring plans under SEGA. So those restructuring plans where you're able to put a particular class of creditor and bind them into an arrangement, because even though they're dissenting, the proposal is best for everyone involved. You may find cases coming through where HMRC are in that class and they're brought into an arrangement, sort of kicking and screaming all the way, even though they're opposed to it, because it's the best outcome for all the creditors. So we may actually see restructuring plans coming through in increased measure as a result of this development. Finally then, I just have some very brief reflections on debtor and creditor considerations. So I think the key considerations for debtors would be these. Firstly, an informal assessment of a business recovery plan. So there are obviously some particular sectors, retail, hospitality, tourism, that have been particularly badly hit by COVID and will need to be now looking at a business recovery plan and what they're going to do. There may be others, obviously, even within your own sector there, who may have some restructuring to do later down the line. And I think the best advice for debtors is to try and be proactive. Typically what happens is On the debtor side of things, it's all left to the last minute, and as a result, then your options are limited. Whereas, as hopefully I've explained this morning, through the new procedures and schemes that are available on the debtor side of things through SEGA, you know, that would be something worth considering at an early stage. Second piece of advice would always be to have early engagement with stakeholders. I think the worst thing from a debtor perspective is to bury the head and hope that it goes away, because inevitably it won't. And if you have a good business, you want to keep it going. And the only way you're going to keep it going is if you keep talking to your stakeholders. And that includes creditors, but also just people involved in the company in general, to make sure that everyone's on board with where you're going. Early engagement then with insolvency specialists, I suppose, yes, people like me, but especially insolvency practitioners, accountants. Know there are insolvency practitioners connected even with CEF here. So, you know, the point being that you should try and engage specialist advisors at an earlier stage. I think particularly at the minute, given the number of options and new options that there are out there, it's best to explore what the best plan is for the business. And like I say, doing this at an early stage will keep a lot of options open, but if it's left to the last minute, then options may be limited. So that would be really the final and the overreaching piece of advice that I would give, is that debtors should make best time of this current situation. Like I mentioned, there's not huge pressure on debtors, and it looks like that may stay like that for a slightly longer period than perhaps previously or originally anticipated. And so make best time of this time afforded to build in a good restructuring and recovery plan. In terms of creditors, I think recommendations would include seeking to limit exposure where possible when the debt is unsecured. So the reality is there's always going to be in a supply chain an element of risk, and so you want to just mitigate that risk best you can. So that maybe comes from just key, dialogue and checking the position of any customers, any people that you're working with, just to make sure that they're going well, asking questions from time to time, just to make sure and satisfy yourself that solvency is good in that business. Obtaining court judgments in respect of larger debts. So quite a number of even clients of ourselves here have been waiting for creditor petitions to be re-engaged before pursuing any debts. And I think we're now, because of the extended period that has been left here, and now what looks like, at least a period of several months still without winding up petitions coming back into play, it probably is a consideration to get a court judgment in respect of a larger debt. That doesn't necessarily secure your position, but it does make it unquestionable that the judgment is there and the debtor can't dispute it at any stage once you have a judgment in your favour. The other consideration would be to review supply contracts to ensure maximum protection. So one of the key examples in there is make sure if you are supplying products, that you have a robust retention of title clauses. We have seen in recent years retention of title clauses typically are a lot more robust, but they used to be the old sort of on an invoice, like a stamp, and no real sort of terms and conditions supplied or anything like that just make it very clear. So again, probably worth just reviewing supply contracts to ensure the company is protected as best as possible. And then finally, a consideration would be in respect of any compromised settlement that's being offered whenever you're dealing with a distressed company. So the reality is that whenever we're owed something and we're being offered a percentage off that, we're never going to be happy, because our best position is to obviously get the full amount back. But it's worth really considering, particularly with how quickly companies on the debtor side of things can disappear. If there is an offer, it may be the kind of bird in the hand type scenario is better in the long run. So that's something worth seriously considering, and indeed, if appropriate, and if it's a large enough amount, worth getting some advice on as well. So in summary then, I suppose some of the key takeaways I would like to leave you with today is that the moratorium is currently really in place because of the temporary restrictions. The current prohibition on winding up petitions is providing quite a lot of breathing space for debtors and indeed creditors to really consider all options. So there will be time here, certainly from the debtor side of things, to think about a plan and put a good plan in place. Again, the encouragement being take that time and use it well. A combination of the potential reduction in access to finance. So perhaps didn't explain that so much earlier, but if you think about the floating charge security now ranking beneath HMRC, you can see how that will be a less attractive security for a lender. So that's going to have an impact on the finance that's available. And also a combination of that and an expensive restructuring plan process may lead in the sort of medium term to an increase in the number of corporate insolvencies. And so it doesn't take a genius perhaps to predict this, but we do think it will be a challenging time ahead for unsecured creditors of insolvent companies. So that's all really I have to say today. I hope that was helpful and useful for you. As Mark mentioned at the start, we're going to take some questions now. And if you do have any burning questions, please feel free to stick those in the Q&A function. Thank you.
Richard, that's tremendous, and that'll let you gather your breath for a minute or two while you have a look at questions that have been submitted. But no, fantastic run through there. And I thought I had a reasonable handle on the jargon until you threw in cross-class cram down, which I can barely say.
Yeah.
It's an interesting time. I mean, obviously these matters, and you've touched on COVID there, and our members will be very aware of them, and it's the current pressures of pricing, particularly through the supply chain and with clients. And as I was mentioning to you before we came on the call, we just sent a further update to the Finance Minister this morning asking for their views, and we need to find mechanisms in the contracts to deal with price increases for public sector clients and so on. You mentioned as well access to finance, so I'll just be shameless and mention that we do have another webinar tomorrow with our other patrons, PKF FPM, on funding. But equally to thank you, Selig. You're right, we have a good program of events coming up from Selig. We have employment law webinar, director's duties, how to deal with fatal accidents, time-related claims, renewable energy, and many more. So we've a good list of very incisive events coming up from Selig. So we do thank everybody in the team there for that. But yes, Richard, if maybe we'll just have a run through now. I know we have a number of questions submitted there. If we want to have a run through those, that would be great.
Okay, well, I have 3 currently, so I'm happy to go through these. The first question asks, will the Crown preference make it more difficult for companies in difficulties or distress to get a restructure over the line? So I think, in fairness, maybe that question was asked possibly just before I finished up there, but what I was touching on in the end was, yes, I do think that will bring with it challenges. And I do feel like the restructuring plan might be the best option from the debtor side of things to try and get round the Crown preferential status. I think as well, I fully expect there will be a fair amount of lobbying depending on the Crown's attitude. I mean, as things currently stand, we don't know what their attitude will be. Historically, it's not been great, and they've been a difficult creditor to deal with in insolvencies. But it may be that will change. We just don't know what sort of guidance they'll be getting, because as we've seen over the past 12 months, there is certainly a lot of sympathy for a lot of sectors who have been hit by this pandemic, and with the legislation coming in and everything else, there's definitely a drive to make sure as many companies as possible survive. So it would really go against the spirit of things if the revenue sort of came in as the Grim Reapers there, destroying every opportunity for companies. So they may even receive some further guidance because they haven't been able to do anything in relation to their current debts. then we just don't know it's hard to predict exactly how they will act, but I do anticipate it will be challenging for sure. The second question then is, if you can't issue a winding up order at the minute, what other options are there to use insolvency as a threat? So the comment then is made, people who owe money seem to have no risk at the minute. Well, I think it's true that they don't have any immediate risk and that there's no immediate threat of insolvency, but the debts will not disappear, I think, is the reality. So it's not sorting out their problems, it's just putting them back a little bit. But I know from a creditor point of view, it is a very frustrating time because we're not able, from the creditor perspective, to push things on as would have been done in normal times. I think, as I said at the end, it is worth considering getting judgments just to put further pressure on the entity. I mean, if you're owed money and that's through an invoice, say in a trading relationship, if you have a judgment there, obviously that's a greater threat against them in terms of potential credit and all that kind of stuff. So you may find that creates a bit more of a threat. I have to say though, historically the biggest threat for any business is a winding up petition, and so because that is not there at the minute, and in fact it seems like the insolvency jurisdiction may be changing its approach. We'll have to just see how that plays out. But I think the view of the insolvency court at the minute, as far as I'm under, the certain impression I get, is that there's maybe too much kind of debt recovery going on there, and so it may be a different sort of process moving forward. Believe it or not, even though I'm sure as many people on the call today will attest, insolvency can get quite contentious. It's set up as a non-contentious business procedure. It's not really supposed to be lots of litigation and disputes and debt recovery, but it's kind of that aspect of litigation has kind of merged into insolvency over the last number of years. So I just think it'll be a different landscape moving forward, and we probably will have to reassess how even businesses on the creditor side of things pursue debts. Final question then is around advice when dealing with insolvency practitioners acting as administrators of a company when the company owes money. Well, as I have said, I mean, there is obviously initially, whenever the appointment comes into play, there's a moratorium there in place, so they get a bit of breathing space. The administrator then obviously has to make a proposal, and it can be again a frustrating time if I'm assuming this question is coming from an unsecured creditor point of view in terms of knowing really what you're going to get. The administrator, it's important to remember, is a licensed insolvency practitioner, is accountable in that regard, and in fact, first and foremost, really, the administrator is an officer of the court. So, they do have to obviously comply with their duties. I'm not sure if that question is asking whether there's a situation where they're not complying. If they are complying with their duties, then I suppose you just have to wait and see what happens. But if there are issues over what the administrator in office is doing, then there are grounds to challenge that. Obviously, you would need to get legal advice on that front. But I think for most administrations, I'm afraid to say on the unsecured creditor side of things, it probably is just it's a patient wait and hoping that something good comes out of it. So that's all I can really say on that one.
Okay, that's great. I think that's all the questions I've received from the members joining us this morning. You've covered the ground very comprehensively. We will be sharing these slides after the event. We'll also be sharing a link to the YouTube recording in case anybody needs to recap or share it. And I know you and the team at Selig are always available if anybody has any queries to send them through. So I will thank you again, Richard. That was a tremendous presentation. Thanks to the team at Selig for pulling that together. We look forward to the next one. And I'll thank everybody for joining us this morning. Hope you find it useful. Thanks very much.
You're very welcome. Thank you.
Thank you.